Good afternoon to everybody. Welcome to the today class, Law of Property, that we are dealing with the last chapter and the last chapter, but one topic would be left over there, and that is the said to be the legatee and the family settlements. Then the last one is the rights and obligations of the legatee. With that, the fifth unit may be over successfully. We roughly taken more than 50 video classes. And that is nothing but 45 hours you are taken. That is called the 45 hours, credit hours for the one semester, and I'm sure that you are going to write the examinations. The date is announced over there, and before I could proceed further, that let me know it whether you are hearing me or not. What I posted on the screen, please read so that I could know it. You are hearing me and I am hearing you. Yes.
Good afternoon, sir.
Good afternoon.
You educate a man. You educate a man. You educate a woman. You educate a generation.
That means,
Young.
yeah, Brigham Young, Professor Dr. Muhammad S. Hussain, that is Muhammad Sahib Hussain. Yeah, that the point of giving this thing is you educate a man, that man will educate another man. But if you educate a woman, the woman educated the entire generation, not only a woman. Entire generation, educate a generation. That is the wording that they are given. That's why that you will say the mother tongue, we don't say the father tongue, because it is the mother who teaches more. That is the reason. Yes, let us come to the point of this, our study is concerned, that I told you that we are going to deal the inheritance, how it will play the important role, and inheritance is concerned. And with this, we will go to the left for the rights and obligations of the legatee. Yes, now the legacy and inheritance is risk from the family settlements, how it can be there. And I'm sure that you could see the screen, is it or not?
Yes,
Could you
sir.
able
It
to
is
see the
visible,
screen?
sir. Yes, sir. It is visible, sir.
Yes. What happens when your will, registered or otherwise, an intestate demise where there is no will or a combination of the factor causes the family to come apart over the differences in the resolution of the person's estate because of the mutual cooperation becomes impossible. Suppose if a person has not written a will, then each relations of the deceased will fight together, because the reason is money makes many things, no doubt. Money creates also the rift in the relations. Yes, because there nobody would compromise, and there will not be any cooperation. Then mutual understanding will not be there. Even when the legatees or beneficiaries and heirs are in a broad consensus, there are many small points over which the beneficiary inherits or beneficiary or inheritors fall out. So the point comes over here is legatee is a beneficiary and the legatee may be a heir. That's why that we will say that instead of saying the devicee and the legatee, they will say the beneficiaries. It is often happened that the wills and similar documents don't cover every possible complexity and wrinkles that can stall on an amicable resolution of your legacy. See, however, maybe the very clearly mentioned over there in the will, but still there are the wrinkles. There are the here the wrinkles in the sense estranged relationship between the own kith and kin and the siblings of the testator. Yes, I have often witnessed, because here the author says that witness is often, very often, even in a close knit families, some of the reasons can be. See, even the close relationship family also, they will get the rift because of the, yes,
Sir, once again, sir.
the close family becomes the jealousy to each other because of the
Their
property,
disparities.
deceased property, deceased
Properties.
property, other property may the movable property or immovable property, real property. Okay, the person
All
who
I
made the will,
all
yeah, any type of the property. So the person who made the will, the testator and heirs, legatee or beneficiaries or inheritors, don't necessarily die in sequence. See the point, no, they survive over there. This brings in a different class of the heirs as defined under the law. Because legatees are a different stage, siblings are a different stage, ascendants are a different stage, descendants are a different stage, and residues are a different stage. So these are all different categories would be there, which are some are very close to the testator, some are very distant relative to the testator. Number two, across the different jurisdictions, people understand their rights differently and then try to impose their understanding from a pursued position of the strength. So now the question comes over there, and which jurisdiction these cases will fall? Because generally, when you come the district, whatever the district jurisdiction will be there, the district court, and which will take up the cases, either a first instance case or an appeal case, whichever it may be. So the people understand the rights differently because the people, the legatees have the different rights would be there for them. And the third is assets have been alienated or have withered away and counterclaim are made. So here the property will be alienated and property will be withered. At that instance, here withered means destroyed or dilapidated or deteriorated. So at that instance, then if the division is not there, then the problem would be there of the testator's death. Then the fourth one is the beneficiary try to change the jurisdiction to one that they find more convenient. So they also make the jurisdiction, see, the people are staying over there to filing the cases. They try to choose the jurisdiction of their own choice. That is called forum convenience. In the Pride International law, that will say forum convenience. So where there would be a convenient to the person, they will file a case. For instance, you take in the divorce cases, and which is the convenient place to the bride? Yes.
For what divorce, sir?
For the divorce, which is the convenient jurisdiction for the bride?
Family court, sir.
I say convenient place to file a case.
There,
Where she brought
section,
up,
sir.
where she brought up, where her parents are there. That is the forum convenience. Are you following me?
Yes, sir, following.
Yeah. Suppose husband from the Hyderabad and wife from the Khammam. Then where she files a case?
There, her own place, sir.
From Khammam. That is the forum convenience to her. Yes, next is multiple other reasons even when will are not being contested. So, if the will is there, there may be some disturbances. If will is not there, again there would be some disturbances would be there. Sir, పెళ్లి చేసుకున్న మనిషి చస్తాడు, పెళ్లి చేసుకోకున్న మనిషి చస్తాడు. ఏది మంచిదండి?
సార్ చేసుకొని చావటం మంచిది సార్.
చేసుకొని చావడం మంచిది. Okay, and upwardly mobile middle class today, whether rural or urban, has a greater mobile and immobile assets to leave behind. At the same time, they don't have the time, inclination, or skill sets to plan their legacies or even make a will. And forget about the anticipating possible problems. This makes it all the more important to work at avoiding typical pitfalls that could stall on an equitable distribution of the inheritances before running off to consultants. A little bit of study is well worth the effort. So whenever the parents have leaving the movable or immobile property in abundance without eating, they accumulated for the sake of the children. At that instance, if they kick the bucket, then the problem comes over there regarding the distribution is concerned. So better not to give them the property, but make them to stand on their own feet and you tell them, now you earn your own property. Okay?
Yes, sir.
Yes. In the Indian context, it is important to know that many communities have their own personal laws. And which one do you fall into that? Because we have the Jains, we have the Sikhs, we have the Buddhists, and we have the Muslims, we have the Christians. So each one they will follow their own personal laws. And with an increasing number of the inter-community marriages and people living under the different jurisdictions, domestic as well as international, are determining this itself can take a long time unless the writers writes a will and specify that it will be under the Indian Succession Act. See, for the Muslims, the personal law will work over there. For the Christians, Indian Succession Act will work over there. And for the Hindus, Buddhists, Jains, Hindu Succession Act will work over there. And people, those who got a special marriage, yes.
Special Marriage Act, sir.
No, the marriage is under Special Marriage Act. What about their inheritance?
Indian Succession Act.
Indian Succession Act will come into the picture. So these are all the aspects. So the broad term family settlement comes into the play as the important document for the future resolution, not the document which were made in the first place by the venerable ancestors. So a family settlement presupposes that the normal and oral communication are unable to resolve the issues. Therefore, it is required to place them in a writing. So whenever the family settlements are there, naturally, it is nothing but either the partition or the inheritance. Either the mostly the ancestral property is concerned, because self-acquired property, even the person who is acquired it, he can sell also without keeping a single pie to the children. And to try to resolve the issue without going into the litigation, generally the intelligent parents will say that, see, we have given to the ladies whatever they want, we give to the daughters, and there is no more the other things they can expect. And the remaining other things I am giving to the one or two sons, and in my life only, that you should not supposed to dispute it. So they will take the signature as everyone, including the daughters and their son-in-laws also, so that tomorrow there will not be any problem at all. So I have often observed that the number of the failed settlements is directly proportional to the value of the real estate involved. So the most of the family settlements comes over there when there is no mutual understanding among the brothers and sisters. And regarding the people tend to go for the settlement because they appear to be a cheaper method. Family settlements make sense only for the large joint families which are in a business and have enormous assets that are jointly managed. So a big, what I say, joint property would be there, then the difficult task would be there. Of course, if the person who could manage it well and he can do and he can run in a better manner. For instance, you take Tata. In Tata, do you think that they see father from grandfather onwards, the same Tata is there, but there is no division at all? Are you following?
Yes, sir. Following, sir.
But when you come to the matter of the again Ambani, there is a division came. Hmm?
Anil Ambani and Mukesh.
Yes. So now let us see that. See, one thing is very much clear. There should be indifferences might be there, but there should not be a division at all. Only one unit till it is exist in the world. See, Bata is there. See, Bata. What is Bata?
It's a shoe company, sir.
It's a shoe company. You can see Bata everywhere and everywhere in the world. Are you following me?
Following, sir.
Yes. See, there is no division of Bata. So, it should not be there also. Okay. Let us, of course, they can expand it to other what I say, products also. So, when it is prepared, a family settlement becomes the base document to divide the assets. In the case of the disagreement, to move into the legal arena, therefore, a badly written settlement becomes a cause for the more litigation. So, whenever you write a will, better try to convince the children and you write a will. And that is the best method. Take the consensus first. And that is the thing. One should have to make it. Because after your death, they will become a, what I say, a deadly enemies also. Therefore, a badly written settlement, that is a will, becomes a cause for the more litigation rather than a means to reduce litigation. So, and favor the person and persons who are sharper. Settlements signed on the basis of the trust between the potential adversaries often on an oxymoron. So here they say a proper settlement with the doing the things is a very peaceful way of living the life. So let us check a checklist of listing to consider while understanding why a family settlement is risky. See, 40 family settlement is risky because there is no understanding between the parties. So number one, check it all the heirs and assets are under the same jurisdiction. So the same jurisdiction would be there. Suppose some property would be there in Hyderabad jurisdiction and some property in Khammam jurisdiction. Then the problem comes over there. Of course, in each jurisdiction they have separate will we can make it also. If some are located abroad and tax laws in different countries or even different states can make a big differences would be there. And wills are better options here because all heirs or beneficiaries can move ahead with their shares or proceed separately while judgments and decision from the courts keep matter in one jurisdiction. So if there is a will is there, naturally people will take according to the will, and if any disputes would be there again, somebody should have to knock the door of the court. But in generally, there no dispute would arise over there unless the testator disinherit the many of them. So that is another point where we can challenge the will. A family settlement, when made, is a part of the family succession planning, often becomes a weak because of the circumstances like the death, marriage, birth, family tree. By definition, keeps evolving. So the marriage, death, something. Sometimes now we cannot predict it also. What will going to happen? At that instance, then we should plan. We should plan the succession in a planning way by writing the will. Excuse me. Understand the concept of the class of heirs. See, I told you that how many class of heirs are there. Excuse me. First, what do you say? First degree heirs, second degree heirs, and third degree heirs. Like that, heirs also we can divide it. And be prepared for the more potential claimants jumping out of the woodwork. And heirs who have been divorced, again remarried, have changed the citizenship, and offspring born out of the wedlock, and who were minors at the time of the settlement, and other possibilities that need to be considered, and solutions planned in advance. So these are the other factors where we can comes the matter of the division. I mean to say will, how it can be made and what is the repercussions would be there if the will is not made. The concept of equal division of the assets and liabilities, cost and efforts and flawed, while the assets aside may be easily divisible by the allocating the share of entitlement of A. So now the question comes over there, if the two properties are there, means two houses are there, at that instance they can easily make only one daughter, one son, so each will take each house because the parents is having a separate house to stay. So at that instance, so long they are the present would be there, they will enjoy it. Once they are dead, they can take the division of it, or they can make okay two shares will be the what I say to the son and one share comes to the daughter. In that way also they can make another success in agreement because for daughter marriage the parents have spent a lot of money and they give the separate gift also in the marriage. That is another point of view. So heirs bring to the negotiation table different tax laws. So heirs are there. They also say if the immobile property is there, then how much the tax should be paid over there. If the movable is there, like the taxable income, which is more there in the bank, then you have to pay the tax. So that was the thing. And next comes the examples of the cost and liabilities that cannot and should not be shared are given below. So who will bear the cost and liabilities? And they say one heir may have to travel from one country to while another may have to take just a local bus for the legal work involved in the claiming the inheritance. How can these costs be shared? See, one fellow stays in another country, but if he wants to take the share, he has to come all the way from that country to this country by paying the air ticket. But another son who stays in the local, even is on foot, he can reach to the place of his father. This is one. Then attesting and documentation mode varies. It is attestation charges are varies and documentation charges are varies from city to city and state to state and country to country. This can add up the substantially the cost of getting document attested by the embassies also there. And for the example, should be borne by that beneficiary who lives abroad. Those costs are pretty stiff. Suppose if any marriage would be conducted, Indian national marriage would be conducted in a foreign country, there is a foreign embassy would be there, there you can conduct your marriage. Yes? Any question?
No, sir.
If the bride and bridegroom are the boy and a girl of the majority reached over there, and they are the Indians, if they want to marry in the South Africa, yes, they can marry in the South Africa by going to the
South Africa.
by going to the South African Indian Embassy.
Yes, sir.
Yes, they can attest it and they will certify it also. That is valid marriage. This is so the different costs should be also depend upon the class of heirs. Sort this out clearly while writing a settlement. For instance, class 1 heirs are there resident in India versus class 2 heirs who is a citizen of foreign country. Just one example. The elaborate class 1 heirs who is in India citizen needs to simply present his ID is enough. But residence proof and the required Indian affidavit, one of the point in affidavit is that there will be no encumbrances or alienation till the assets are distributed. So whenever any property will be disposed of, it is very much clearly mentioned there whether it is having any encumbrances. EC. So EC should be taken first. So class 1 and class 2 are more heirs who is a foreign citizens will need to be proved bona fide or also obtain the attestation by the respective embassies. Yes, they have to take the respective embassy's signature and attestation is very much essential. And often also provide a indemnity is acceptable and enforceable in the country or state of jurisdiction of that suit. When that comes, especially the people are from the different countries, those who are legatees. Next comes the taxation and liens of an individual nature are certainly going to be different. Yes, the country is different. And here abroad, usually have some sort of mortgages. Sometimes people avail of the loans abroad by offering assets in India the collateral. Of course, they will get the the loan in the foreign country by showing the property in the India. That's why encumbrances would be there. Permitting this in case of the joint family is a huge risk that wake up in the learn about only one when the fat yellow envelopes lands up at your home. So now the question comes over there when the matter comes the bulky, especially for the foreign settlements are there, where the legatee from one country and another legatee from one country. Then the question comes over there in the settlements. Of course, where there is a way, there is a will, there is a way. Definitely the way would be there where it can be settled and how it can be settled also clearly mentioned. Next, there is a tricky wood called say signs which can be seen in many settlements deeds. What does a sign means? Legal definitions are available all over, but broadly it means that a participant in a settlement can part with the rights and obligations and more what he share. So whatever the share that he will be going to get it, he can assign to somebody else. Even if he or she does not own it at that juncture, when still it is she did not because first succession is we saw he is going to get it, and that what he is going to get it after getting that he can make it implement. So don't accept the word essence in any form till the assets and liabilities have been sorted out and have got your share in your bank. So when the assigns comes over there, at that instant, there is going to get from his father, from holding in the position is different. So never believe the word assign. Whenever the property once become a owner of it, then only we can expect to give in the form of a will. There is always a narration of the facts included in a settlement deed. If your understanding of the narration is different, it can become the basis of the future litigation. సార్ మా నాయన రాసిండు ఏం రాసిండ మా నాన్న రాసిండు ఒక ఇల్లేమో పెద్దోనికి ఇంకొక ఇల్లేమో చిన్నోనికి ఏమన్నట్టంటే అది రెండు ఇండ్లు ఉన్నాయి వాళ్ళ నాయనకు ఒక ఇల్లేమో పెద్దోనికి ఒక ఇల్లేమో చిన్నోనికి చెప్పండి
Vague, sir. Vague. It is a vague.
అవుతుంది షుడ్ బి స్పెసిఫిక్ which house name and the jurisdiction. I mean to say it's a sketch, it is boundaries, and it is how much the worth of it, how much the square meters or square kilometers or square yards, and all those things should be clearly mentioned, and a sketch will be prepared by the surveyor, and then only it can be made. Yes, this is the thing which is going to be given for the will. And a written statement, okay, one house is there, you need not to say. If only one house is there, then you take half of it. Okay, let them take half of it, half share, half share. So remember, a written settlement is made to avoid disputes and differences. So always a written statement must be there, and so that there is no ambiguity would be there, no vagueness is there. So contributing to the effort by the reading and each word of the draft carefully while the settlement is being prepared. And after never be rushed into any sort of settlement. That is, if you can research the subject online, there is a wealth of information available who can go wrong with the distribution of immovable property. And finally, that beware of the snowflakes in your own family. It is not necessary that their interests are alienated with yours. For instance, if you has a grandparent cash in your immovable assets in your lifetime, and what is left for the grandchildren, and if you don't have enough to see, you throw your twilight eyes years, and your grandchildren may have a legitimate concern about the financial burden unless they abandon a helpless senior citizen. So naturally, when the ancestral property is there, yes, it passes from the grandfather to the father, father to the son, son to the son to the
Grandson, sir.
grandson. So if you don't draft the settlement, that is, the incorrectly drafted settlement often lead to the more litigation than they were supposed to avoid. ఇప్పుడు ఏమన్నంటే పెళ్ళం అంటది ఎవరికి మగాయంతో ఆయన హస్బెండ్తో, నేను చచ్చిపోయిన తర్వాత కూడా నీకు పీడిస్తా అంటది. వీడు పరిశాన్ అయిపోయి చచ్చిపోయిన తర్వాత ఎట్లా పీడిస్తారు చెప్పండి సార్.
Sir, maybe will through will, sir.
పెళ్ళం రాస్తుంది అంటే ఈ వీళ్ళు. Of course, if she is having the property on her own name, she can lift it. But in another way is there, చచ్చిపోయిన తర్వాత పీడిస్తా అనేది అంటే ఇది కళలా కాదనుకోండి. ఏం చేస్తుందంటే ఇది నేచురల్ డెత్ కూడా అయిన తర్వాత ఏం చేస్తుంది అని ఒక స్లిప్ రాస్తుంది. బికాజ్ ఇట్ ఈస్ మై హస్బెండ్ హూ హాజ్ కిల్డ్ మీ అని రాసి పడేసింది అనుకోండి, ఏమవుతుందండి?
Case against the husband, sir.
అని చచ్చిపోయిన కూడా పీడిస్తుంది అని అన్నదా కదా.
Yes, sir.
Even though she had the natural death, but she wants to make it. Of course, very few people are there in that way. They will take the revenge after the death also. Yes, don't rush into the family settlement without considering all the pitfalls. So whenever you want to write a real and a settlement, you see each aspect of it, then you have to start it. So the list above is very minimal and just starting point. You see what should be taken, what should not be taken, and how to write it, and how to make it out, the pitfalls, especially writing the will. సార్ వీరునామా రాసి చచ్చిపోవడం మంచిదా లేకుంటే రాయకపోవడం చచ్చిపోవడం మంచిదా అండి?
Sir, it is better to write and
The best method is write. Before writing, call them everybody. Call them everybody so that it should not be a surprise thing to them. Are you following me? సార్ అక్కడ అత్తరా సరాడు సపదవానికి ఎవరికైనా ఎక్కువ వచ్చింది అనుకో తక్కువ వచ్చింది అనుకో అప్పుడు వాడు ఊపుకుంటాడా సార్. బట్ జనరల్లీ no father mother could do so. They will justify it why they have given more to the one son or one daughter, why they have given less to one, and the justification is always there, and that justification will definitely will not create any problem to the children. ఇప్పుడు పెద్ద కొడుకున్నాడు చిన్న కొడుకున్నాడు, ఇప్పుడు చాక్లెట్లు పట్టుకొచ్చింది. దాంట్లో ఒక చాక్లెట్ కాస్ట్లీది ఉన్నది, ఒక చాక్లెట్ ఏమో తక్కువ కాస్ట్లీ ఉన్నది. కానీ కాస్ట్ మాత్రం ఇద్దరు పిల్లలకు ఎవరికి తెలుస్తుందండి కాస్ట్ ఎక్కువ? పెద్దవాడికి తెలుస్తుంది కాస్ట్ ఏ ఉన్నది. కానీ అట్రాక్టివ్నెస్ చూస్తే చిన్నది మంచిగా ఉంటుంది. సో వాడు ఏం చేస్తారు తెలుసా, అట్రాక్టివ్నెస్ బాగా చూసి తమ్మునికి ఇచ్చేస్తారు. ఎందుకంటే ఈ విల్ వెరీ మచ్ అట్రాక్టెడ్ బై దట్ ర్యాపర్ అనుకోండి, అది షేప్ అనుకోండి, అదండి. బికాస్ హీ నోస్ ఇట్ ఈస్ ఎ కాస్ట్లీ వన్ అండ్ he will, and what more he did know, he will never reveal the cost of it first. అరే తమ్ముడా నువ్వు ఏది కావాలో చూసుకోరా అని రెండిట్లో పెడతారు. కానీ తమ్ముడు ఏం చేస్తుంటే having a less knowledge of it, no, he will take the attractiveness the more, then definitely that he is going to get what he wants. So better give a chance to the other person to choose it. ఇప్పుడు సపోజ్ ఒకటే యాపిల్ ఉన్నదండి, ఇద్దరు సరిసమం పంచుకోవాలి. ఇప్పుడు ఏ విధంగా బెస్ట్ మెథడ్ చెప్పండి సార్? మెజర్ పెట్టి కరెక్ట్ గా కట్ చేయాలి. అందులో కూడా కొంచెం స్లిప్ అయింది అనుకోండి, మెజర్ పెట్టి చేసి చేయడం కన్నా ద బెస్ట్ మెథడ్ చెప్పాలన్నా మీకు? ఎస్
చెప్పండి సార్.
ఐ కట్ యూ చూస్. చెప్పండి.
గుడ్ ఐడియా సార్.
దట్ ఈస్ ద బెస్ట్ ఐడియా. అరే నువ్వు కట్ చేయరా బాబు, నీ ఇష్టం వచ్చినట్టు కట్ చేయి. ఏమంటావు? నీ ఇష్టం వచ్చినట్టు కట్ చేయి, నేను చూజ్ చేసుకుంటా. వాడు ఏం చెప్తాడు సార్, ఏ మాత్రం కాకుండా కట్ చేస్తాడు, సైంటిఫిక్ వేరే కట్ చేస్తాడు, ఎందుకంటే ఎక్కువ పోతుంది. That is the best idea for that making the things. So, and if any of the beneficiaries or legatees or heirs or foreign citizens are live abroad, then a settlement or registered or otherwise, it is often not with the paper it is printed on. If they can't trust you in India, then only why? How can you trust them in some other country beyond the reach of Indian authorities? సో ఇటువంటి బిల్లు ఏమవుతుందంటే ఇప్పుడు జనరల్లీ నోటరీ కాదు, రిజిస్టరే చేస్తారు. ఈ రిజిస్టర్ చేసిన తర్వాత ఈ గోస్ ద ఫారెన్ కంట్రీలో అథెంటికే కాదా అని ఎవరు చేస్తారో తెలుసా అండి? ఎంబసీ చేస్తుంది. ఎంబసీ సంతకం పెట్టింది అనుకోండి, అథెంటిక్ అది. ఈవెన్ మ్యారేజ్ కూడా ఇఫ్ ద ఎంబసీ సైన్స్ ఇట్, ఇఫ్ యు షో ఇన్ ఇండియా, ఇట్స్ ఇస్ వ్యాలిడ్ మ్యారేజ్. And of course, our certificates, because you might have seen the newspaper, there is a big factory in Hyderabad selling the certificates. Have you heard?
Yes, sir.
Yeah. People are, ఏది కావాలా, మెడిసిన్ కావాలన్నా, ఇంజనీరింగ్ కావాలన్నా, అరే బాబా మెడిసిన్ అమ్ముతారా బాబు?
ఏ డేట్ లో వచ్చింది సార్?
అది వాట్సాప్ లో వేసినట్టు కదా, నిన్న వేసి వాట్సాప్ లో, గూగుల్లో చూసాను నేను. గూగుల్లో ఐ సా ఇట్, ఏ రాకెట్ హ్యాస్ కమ్ అవుట్, దే ఆర్ సెల్లింగ్ ఇట్. అండ్ మోస్ట్లీ దీస్ ఈ సర్టిఫికెట్లు ఇక్కడ ఇండియాలో యూజ్ చేయరండి. ఇది అదర్ కంట్రీస్, ఎస్పెషల్లీ గల్ఫ్ అండ్ అదర్ కంట్రీస్ దే యూజ్ ఇట్. దట్ ఈస్ ద రీజన్ వాట్ వెనెవర్ ద సర్టిఫికెట్స్ ఆర్ యు ఆర్ వర్కింగ్, ఫర్ ఇన్స్టెన్స్ ఫారిన్ కంట్రీ, వాట్ డూ దే డూ నో? They say let it be endorsed by the general administration plus the foreign affairs. The foreign affairs certificate, the endorsement would be there at the back of the certificate. Then they only consider it is genuine certificate, and that is the endorsement is must. Otherwise, no people will make it out, and they are, of course, I heard that even though they can make the endorsement also in that way. ఈవెన్ ద GAD అండ్ ఫారెన్ అఫైర్స్. సార్ ఇక వారికి చెప్పిన కదా, తెలివివంతుడు వాడు ఎక్కడ కూర్చున్నా సంపాదిస్తానండి. వాడు ఎక్కడ పెట్టినా కూడా నాట్ కీప్ క్వైట్, విల్ ట్రై టు మేక్ ద మనీ బికాస్ ఇట్ ఈస్ హీ హూ నోస్ హౌ టు ప్లే ద గేమ్. అండ్ ఇఫ్ ఎనీ వన్ ది బెనిఫిషియరీ ఆ లెగాటీ, బెనిఫిషియరీ కానివ్వండి, లెగాటీ అని కానివ్వండి, హెయిర్ కానివ్వండి, ఫారిన్ సిటిజన్స్ అండ్ టు లివ్ అబ్రాడ్, దెన్ ద సెటిల్మెంట్ అటువంటిప్పుడు మాత్రము it should be registered, and that registration should be again authenticated with their embassies also. It's often worth with the paper it is printed. If they cannot trust you in India, then why and how can they trust them in some other country beyond the reach of Indian authorities? So this is the settlements where the people will do it. And the last unit is it is nothing but the rights and obligations of the legatee. And there I found in the Indian Succession Act, at least I found some 25, what I say, the rights and obligations are there of the legatee. Of course, some of them we read it also in the when you are dealing about the other kinds of it, like onerous will. చెప్పండి, ఓనరస్ విల్ చెప్పండి
సార్. ఓనరస్ అంటే వన్ సైడ్ సార్,
చెప్పాలి.
వన్ సైడ్ వ్యూ సార్.
వన్ సైడ్ వ్యూ అంటే ఏంటిది? నేను చెప్పాను. సపోజ్ ఇచ్చిండు, ఏది విల్లో, ఒకడేమో కంపెనీ స్టాక్ ఫుల్గా బిజినెస్ ప్రాఫిట్కి వచ్చే కంపెనీ షేర్స్ ఇచ్చిండు, ఇంకోటేమో లాస్కి పోయే షేర్స్కి ఇచ్చిండు. ఇప్పుడు తీసుకుంటే రెండు తీసుకోవాలా, ఒకటే ట్రాన్సాక్షన్లో, నాట్ సపరేట్ ట్రాన్సాక్షన్. తీసుకుంటే రెండు తీసుకోవాలా, తీసుకోకపోతే
ఏది
తీసుకోవద్దు. అదే దాన్ని ఓనరస్ గిఫ్ట్ అంటారు, సారీ ఓనరస్ విల్స్ అంటారు. సో పర్సన్ కెనాట్ బ్లో హాట్ అండ్ కోల్డ్ ఎయిర్ ఎట్ ఎ టైమ్. So legatees, I compiled the legatees rights and obligations nearly 20 compiled from going through the Indian Succession Act, and what are the rights would be there, what are the legality. I made it around about 20. Just for a glance I will show you here. Rights, RIGHT, rights. Yes, here. No, rights of the liability, not obligations. This is right and liability buyer, the liability mortgage, seller. Yes, rights and obligation of the legatee. The rights and the obligations of the legatee under the Indian Succession Act 1925. The small Roman Ganapatan Judandi. Small Roman. This is the way that I made. 1 here, 2, small Roman, 3, 4, 5. I compiled out this. This is 5th, this is 6th, this is 7th. Can you able to see?
Yes, sir.
This is the 8th, which is the blue color. Blue అంటారా అని దాన్ని పర్పుల్ అంటారా?
పర్పుల్ సార్.
తెలుగులో ఏమనాలండి?
వంకాయ రంగు.
వంకాయ రంగు అనాలనా సార్, బచ్చల రంగు అనాలనా?
అట్లా కూడా అనొచ్చు సార్.
అది 9, 10, 11, so 12. So if you go to that now, I made 20 roughly. This is 18, this is 19, and this is 20. That is a 366 section residue after the usual payments to be paid to the residuary legatee. అటువంటిది residuary legatee ఎవరంటే the surplus of the or residue of the deceased property after payment of debts and legacies shall be paid to the residuary legatee where any has been appointed by the will. అది విల్లో ఉన్నదనుకోండి, మిగిలిది ఏదైనా ఉంటే రెసిడ్యూ లెగాటీకి ఇవ్వండి అని రాసింది అనుకోండి. ప్రాపర్టీ డిస్ట్రిబ్యూషన్ తర్వాత ఏదైనా మిగిలింది అనుకోండి, ద విల్ రాసినట్టుగా ఏమవుతుంది, అది రెసిడరీ లెగాటీకి వెళ్తుంది. అట్లా. సో యూనివర్సల్ లెగాటీ మనకు తెలుసు, రెసిడ్యువల్స్ లెగాటీ తెలుసు, డెమాన్స్ట్రేటివ్ లెగాటీస్ తెలుసు. మనం విల్ ఆల్సో సీ the types of the legatees when you make it out one after another. And now the time is 3:28, and only 2 minutes are left because our class ends by 3:30, because we started at the 2:45. 45 minutes are there, and if I take 1 hour because the 20, I think I can. It will take at least for me 2 classes or 3 classes. With that, the entire law of property will be successfully in a better manner we completed it. But in the same time, the law of insurance I completed very early, and the revision is going on over there for the fifth semester people, because the insurance is less in syllabus. But here, law of property is a very big one. In some other places, it is the 2 semester course. It's not 1 semester course. Like in the law of tort, in other countries, it's the 2 semester course. But here, law of tort, you study only 1 semester course. So it's more better it's a 2 semester course, because we can deal it in depth manner. But it will possible only when the law is not 3 years course, it should be the 4 years course. So that would be the point. So with this, I would like to say goodbye. Before I say goodbye to you, generally that I would like to show you the, yes, this is the thing. Can you read? Yes.
Thanks a lot. Thanks a lot for your patience listening and watching my online classes by participating with great interest and care. Professor Dr. Muhammad Sahib Hussain.
Good, good. So with this, that I would like to stop it. And I told you that my mission, if one person also will be benefited by my lectures, I feel that my mission is fulfilled. So with this, that I would like to close up, because Anni Danamula Kanna Vidya Danam Minna, that I believe.